Have any questions, sir?
No fucking nerves!
21 and you have all these priors? What the heck, man?
Everybody perfect.
Don't say anything. It's a rhetorical question. 1, 2, 3, 4. Assault, criminal trespass, attempted assault on a public servant, possession of a controlled substance, unauthorized absence from a correctional facility, felony retaliation, assault, felony assault, assault of a public servant, harassment of a public servant, assault of a public servant, now 2 counts of a burglary of a motor vehicle and a robbery. Something's not taking. Let's do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you. Please.
On May 22nd, 2024, officers responded to an apartment complex and observed the defendant detained by citizens. Complainant advised that he was inside of his apartment and observed the defendant sitting in the driver's seat of his vehicle. Complainant got his brother, went outside, and observed the defendant walking away. Complainant and his brother attempted to stop the defendant and got into a physical altercation with him. And at one point, defendant pepper sprayed complainant's brother. 3 other tenants heard the commotion and came outside to also find that their vehicles had been broken into and they were unable to start due to damage to their control panels. One complainant advised that his phone was taken from his car. Defendant was found with the phone and a programming device used to start cars without their keys, and defendant admitted to burglarizing the vehicle.
Was the robbery due to the pepper spray?
One moment.
Everything I was already taken. I don't see where the robbery comes in. He took everything from the vehicle.
Yes, Judge. It is charged. It is pled as spraying the complainant. The robbery.
With the intent to obtain and maintain control of the property, intentionally or knowingly and recklessly cause the bodily injury by spraying the complainant with a chemical agent. Not only that, you're enhanced with the felony retaliation. So are we looking at a 15 to life? Jay, is this a 15 to life case? Our case number is 2511-521. Fifth, it's elevated to a 5 to life.
All right, folks, buckle up, because what you just heard is the judge laying down bond conditions after reading off a rap sheet longer than most people's resumes. At just 21, this defendant is staring down a possible 5 to life sentence. But the drama here isn't just the charges, it's the judge openly questioning whether public safety is even possible with this man out on the streets. What do you think? Should someone this young, with this many priors, even be considered for release?
I don't know about giving you a PR bond, man. All I care about is public safety, Mr. Haywood, and I don't know if we get it with you. I'm ordering you now as a condition of your bond, if you get out, to remain under home confinement, to have a GPS monitor, not to have any contact with the complaining witness, and not to go in 1,000 feet of this apartment. It's an apartment complex?
Yes, sir.
Not to go within 1,000 feet of this apartment complex. No weapons, undergo random drug testing for alcohol and any kind of dope. Your bond now is set at $15,000 in the robbery case. They gave you PR bonds with ours. I don't know if I'm down with that, you know, not with that kind of criminal history and the fact that he just had an assault dismissed of servant. So guys, please, home confinement, no weapons.
He does work at a tire shop on,
Really?
Yes, sir. My other job was in Dickerson, Texas. It's the same people. I was doing moonwalks and tires, sir.
You scare me, Mr. Haywood. Truly. At 21 and with 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 priors at 21, and now you're charged with 3 cases, one of those being a 5 to life first-degree felony? Ha! I'm sorry, Alan. He scares me. Just bottom line. My only concern is public safety, Mr. Haywood. That's all I care about in this life. You know, you live in Texas. You don't live in Montana, Wyoming. People like their guns and they like their cars.
And here's where things get real. The judge isn't mincing words. He flat out admits he's scared of the defendant. Think about that for a second. A Texas judge who's seen it all is visibly unsettled by the way this 21-year-old looks at him. That's not common courtroom talk, folks. If the judge feels threatened, imagine how the public feels. Do you think the system is doing enough to protect the community in cases like this?
Not a month ago, someone died from a gunshot because of breaking into a car. And the way you look at me now tells me what I can look forward to. All right. Please don't send him down because we need him to sign conditions, please. There's no co-defendant, or was there a co-defendant? If there is no contact with the co-defendants.
No co-defendant.
No co-defendants, there's just him? Got it. You were charged with indecent exposure. You wanted to do the PC on indecent?
Yes, Your Honor.
You're charged with indecent exposure. You are facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during any questions and interviews with the state of Texas. If you cannot afford a lawyer will be appointed to represent you, sir.
May 26, 2024, officers were dispatched to a defendant touching his private area at the Metro-owned downtown transit center located on 1900 Main Street, Harris County, Texas. The officer was advised by Metro Dispatch that the complainant called and stated that the defendant was exposing himself to her. Complainant told officers that the defendant was a black male in a blue hoodie and boarded a Metro bus, and then ultimately pointed the bus that he had boarded. Individuals matching the description, and complainant witness confirmed that that was the same person. Complainant stated that the defendant followed her from across the street, pulled out his penis, and started exposing it to her and looking at her. She further stated that the defendant began stroking his penis back and forth with his hands, looking at her without speaking, approximately 5 to 10 feet away. The complainant stated that she was unable to tell if he was erect, but she was able to clearly see his penis as he was stroking.
Your Honor, after speaking with my
Now, this next case takes a sharp left turn, from burglary and assault to indecent exposure. And it's not just a rumor. The complainant says she watched the act unfold just feet away. The defense is already poking holes, claiming it might have been someone else. But until the body cam footage is reviewed, the judge has no choice but to move forward. Here's the big question for you. Should probable cause be enough to hold someone, or should solid evidence always come first?
client, the officers approached 2 males. I have to wait on body cam to see what the other male looked like, but my client's saying that wasn't him. He just
I mean, I don't know. I think that there's probable cause to go forward now. Mr. Lane. Mr. Lane, we will get the body cam to ensure and see if that is in fact you, because we don't know. All we know is that we have someone that has identified you. I will try to have them get the body. Do you have it now? What evidence do you have now?
This is a brand new case, Your Honor. This is the 26th, so I don't know. There's nothing in yet. So I literally just wrote this up before I came to court.
Okay. Mr. Lane, I will try to have them get the information and the body cams as quick as possible so we can verify that it is you. I would say let's try hopefully a week. The problem is that I can't give you a PR bond because you continue to take off on us. I had your evading arrest at 7503 because we can't get you here. So, okay. Do you have any questions, sir? Right now, you're on probation for a felon in possession of a weapon. You're also on probation for possession of a controlled substance in the felony case. You picked up in April with us, you picked up an assault bodily injury. You have literally been given 3 PR bonds and you continue to take off.
I didn't get PR bond, sir.
But you have. I'm showing that you failed to appear 516.
I just got a PR bond, sir. Excuse me.
Listen to the day.
So Roberto, please don't go. Okay, so I have 3 different occasions.
Notice how the judge keeps circling back to one key issue: failure to appear. You can argue about charges all day, but if someone doesn't show up to court, the whole system breaks down. And in this case, it's happened multiple times. The defendant insists it's not his fault, blaming bond issues and co-signers, but the judge isn't buying it. If you were on the bench, would you take that risk and grant him another chance?
That you failed to appear. I cannot, in my good conscience, give you a PR bond when you continue to take off, because I know if we give you another PR bond, what's going to happen?
I haven't had a PR bond, sir. I bonded out, and it's the only reason I'm back right here right now, sir, is because someone took their name off the bond. I haven't did anything else and gotten in trouble. Someone just took their name off the bond because I couldn't get a co-signer. That's the only reason I'm back in jail right now.
I also have that you have failed to appear on 3 different occasions.
I
Okay,
haven't.
so what we're doing, regardless, your bonds are set at $55,000 upstairs.
And I'm going to make the bond this Saturday. That way I can take care of this stuff
You
better.
make the bond, I am now going to make you wear a GPS monitor so I know where you are at all times, okay?
Yes, sir.
But I cannot give you a PR bond in this case, okay? Because you just don't show up when we ask you to show up. So regardless, you have Greg representing you now. If you do get out, please stay in contact with him. If you get out, you post bond and you jet on me again, Ms. Gallardoni, I'm going to triple, if not quadruple the bond.
Thank
You
you, Judge.
understand?
Yes, sir.
All we're asking you to do is show up.
All right.
That's it. And stay out of trouble.
All right.
Okay?
Yes, sir.
I know that the felony courts are trying to have you evaluated as well. Do it, because if you don't, the only thing it does is it prolongs your case even more.
Okay.
Okay?
Yes, sir.
I think that we're okay. I don't think that there's,
Okay, Your Honor. Thank you.
yeah. So,
I don't think I'm not showing a felony court date for her, but then I was showing,
I am showing 7/29.
okay, you got that 7/29 phone.
Your court date for your felony cases are July 29th. Okay?
Yes, sir.
We don't do that long. Okay? We'll do just 30 days and then we'll come back and then go from there.
Okay, Your Honor. Perfect.
Thanks, Steve. Appreciate it. All right. Good luck, Ms. Gallardo.
All right. Thank you.
Yes, ma'am.
So here's where it all lands: multiple charges, repeated no-shows, and a judge who's clearly running out of patience. Between 5 to life felonies and fresh misdemeanors, this courtroom is juggling public safety, fairness, and credibility all at once. Cases like these remind us just how fine the line is between second chances and serious consequences. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.